Welcome back to the Deep Dive. We're here again to really get beneath the surface, cutting through the chatter to find what truly matters. And if you followed our Beyond the Hype series, you'll know we've looked closely at Cliqly before. For so many of you, especially if you're in online marketing or you've used affiliate programs, Cliqly wasn't just some company name. It felt like, well, a real opportunity, a place where you put in time, real effort, hoping for those commission checks. We've explored their model, the community, the ongoing questions about payment. But today, our deep dive takes a much more serious turn. This isn't speculation. It's an urgent update, a critical one. We're pulling back the curtain on some really concerning things happening with DE Marketing LLC. That's the parent company for Cliqly and this supposedly new sister company, Clicker. What we found isn't just a business facing difficulties. It honestly looks more like a calculated strategy. Cliqly, acting through Clicker, seems to be operating just like always signing people up, promising big payouts while behind the scenes quietly trying to file for bankruptcy.
The impact this could have, the devastating impact on thousands of people still hoping for their commissions. It's huge. It's a stark look at corporate accountability, or maybe the lack of it, right?
It really is. And this whole situation just highlights how incredibly important it is to understand these official filings, the legal stuff, the financial documents. They aren't just dry paperwork. They're public records. And if you dig into them, analyze them carefully, they can reveal some pretty shocking things. Hidden agendas,
Yeah.
They're absolutely vital for anyone caught up in a company's financial troubles. Now, usually when a company files for Chapter 7 bankruptcy, the general idea is they stop operating. Their assets get sold off, liquidated to pay creditors. It's supposed to be transparent, fair. But digging through the DE Marketing LLC documents, we're seeing something very different. It really suggests a deliberate attempt to hide information, maybe even dodge the responsibilities. So the big question driving us today, the one we need to answer is, what does all of this legal maneuvering, this continued operation, what does it actually mean for the thousands of people owed money, people who likely had no idea this bankruptcy was even happening?
Okay, let's really get into this, and there's a lot here. Believe me, we're talking about DE Marketing LLC. That's the company behind Cliqly, and also Conversion House Media, which some of you might know too. For so many people, maybe even you listening, this isn't just some corporate name on a piece of paper. This is where you invested your time, your effort, your real hope for those commission payouts. We've heard from so many who worked hard on these platforms, really believing the promises. So the key discovery, the thing that really set off alarm bells for us, is that DE Marketing LLC filed for Chapter 7 bankruptcy quietly. No big announcement, no emails to all the users saying, hey, this is happening. Just a silent legal move. This happened on June 9th, 2025, filed in the Southern District of Texas. If you want to look it up yourself in the public records, the case number is 4.25 BK 33305. It's public, sure, but it feels like it was meant to fly under the radar for most people affected. Now, Chapter 7 bankruptcy. What does that actually mean for a company if you're not familiar with bankruptcy law? Well, basically, it means the company is shutting down. It stops operations.
Then, a Chapter 7 trustee gets appointed in this case. It's Ronald J. Summers. His job is basically to sell off any assets the company has that aren't protected, non-exempt assets. Unlike a person filing bankruptcy who might get their debts wiped clean, a discharge accompanying in Chapter 7 just dissolves after the assets are sold. The whole point is to gather whatever value is left, turn it into cash, and share it out fairly to everyone the company owes money to. Creditors, right? It's meant to be the end of the line, done openly.
But what's really striking here, and honestly quite disturbing, is the massive gap between what this initial filing looks like, what it claims, and the reality we've pieced together. It immediately makes you ask, okay, what exactly did they put down on paper in that first filing? Because those initial declarations, that's often where you find the biggest glues, the biggest red flags.
Right. So on their official Form 201, that's the voluntary petition, basically the We Declare Bankruptcy form they file with the court, DE Marketing LLC, made some very specific claims. And these claims are, well, let's say highly questionable. First, they estimated the number of creditors, people or companies they owe money to, at just 1 to 49.
1 to 49, seriously.
Yes, 1 to 49. Just let that sink in. Knowing what we know now about the thousands of unpaid members, it's a shocking contrast. Second, they estimated their total assets, what they own, at a tiny 0 to 50,000.
$50,000 max. That's what they declared. 0 to 50,000. But on the flip side, their estimated liabilities, what they owe, they put that much higher. $1 million to $10 million. And here's the real kicker. The statement that's like a gut punch for anyone waiting on commissions. They wrote, quite clearly, no funds available for distribution to unsecured creditors after administrative expenses are paid.
Wow. So basically,
Sorry, nothing left for you.
Precisely. The implication is huge. If the court just accepted that statement at face value without digging deeper, it means pretty much zero chance of recovery for most creditors, especially unsecured creditors.
And those unpaid contractors, the members, they'd be unsecured, right?
Generally, yes. That category often includes suppliers, service providers, and independent contractors owed money. It essentially signals that after legal fees and bankruptcy costs, the pot is empty. And it's important to see which specific brands they listed under this bankruptcy. The DBAs, the doing business as names, they listed Cliqly email marketing, Cliqly Cliqly.com, Cliqly email, Cliqly traffic, Cliqly itself, Conversion House Media, and conversionhousemedia.com. This is key because it formally ties all those familiar platforms, the ones you likely interacted with, directly to this bankruptcy filing. They're all legally part of this one entity that's now claiming it has nothing left for the people it owes millions to people who worked under those very brand names.
Okay, this is where it just gets, well, frankly, infuriating.
Yeah.
And really suspicious.
Yeah.
If a company admits it owes millions, between $1 and $10, they said, how on earth can they claim fewer than 50 creditors? It just doesn't make sense. So what does this huge gap mean? For you, for anyone who put in the work, expecting to get paid. The heart of the issue, the really blatant inconsistency, is that claim of 149 creditors versus the reality. The reality we know involves over 3,000 people.
At least 3,000?
Right. At least 3,000 people who are owed, collectively, something like $2 million in commissions. And these people, maybe you listening, you're classified as independent contractors, not employees. Now, that difference matters in bankruptcy sometimes, for priority, but it absolutely doesn't change the fact that you are creditors. The company owes you money, period. And we have proof. Hard proof. Think about this. Hundreds, maybe thousands of you receive 1099 tax forms from DE Marketing LLC. Companies send those out to report income paid to contractors, right? But here's the crazy part. These 1099s were for income you never actually received.
Astonishing.
Isn't it? The company told the IRS they paid you, but the money never hit your account. That's not just someone's story. That's a legal document. A smoking gun. Issuing those 1099s legally establishes you as a creditor of DE Marketing LLC. There's just no way around that. And this kind of behavior, it fits a pattern, sadly. We've heard so many reports about Cliqly's terms of service changing all the time, often without warning. And for nearly 2 years, right? Emails from support kept saying payments were coming, just delayed, but commissions kept falling further and further behind. Some people waited up to 2 years.
It paints a picture of long-term issues, not a sudden collapse.
Exactly. So this isn't some sudden problem. It makes the bankruptcy filing, especially with these claims, look even more, well, more calculated, maybe even premeditated.
And that huge discrepancy brings up a really fundamental legal point. If you're a company and you owe money especially to thousands of people you even sent tax forms to, are you legally required to list them all in your bankruptcy filing? The answer is absolutely, unequivocally yes.
No wiggle room.
Zero. Under Chapter 7, the law mandates it requires the company to list all its debts and all its creditors. This isn't optional. It's a cornerstone of the whole process. Fairness, transparency. Every single person who got a 1099 for unpaid work has to be on Schedule EF, that's the list of creditors, and, crucially, on the creditor mailing matrix. Think of the matrix as the court's official address list. It's used to make sure everyone owed money gets formal notice about the case. An unpaid 1099 contractor is, legally speaking, an unsecured creditor. They have a right to payment. They must be listed. And here's what we found in the actual court documents. It's genuinely shocking. The creditor matrix, which is document 1 in the public file, listed only 7 entities.
Some nice, not 7,000, just 7.
7 total. And who were they? Mostly a few law firms, some service companies, and maybe 3 or 4 merchant cash advance lenders. Not one single independent contractor, not one platform user, none of you. It's a staggering omission. Plus, there's an entry on June 10th noted as no creditor mailing list, KEG 4, in document 4. That explicitly shows they didn't even submit a proper list right at the start. And then the certificate of notice, also in document 4, dated June 12th. It states clearly that only DE Marketing LLC itself got mailed notice, and electronically it says none.
So they basically ensured nobody else would find out officially.
It certainly looks that way. You, the thousands owed money, were systematically kept off the list, kept from getting official notice. They seemingly wanted to keep you completely in the dark. The legal fallout from omitting creditors like this is incredibly serious. This isn't just sloppy paperwork. It's a material misrepresentation. It's a false statement made under penalty of perjury.
Meaning they swore it was true.
Exactly. They declared under oath that this information was accurate knowing it wasn't. That can lead straight to criminal penalties for bankruptcy fraud. We're talking federal charges under 18 U.S.C. Section 152. It's about trying to cheat the system, cheat the creditors. And fundamentally, it strips legitimate creditors like you of your basic legal rights, the right to know about the bankruptcy, the right to file a claim for your money, the right to object if you suspect fraud. It points strongly towards a deliberate, thought-out attempt to hide debts, to avoid disclosure, trying to make thousands of creditors just disappear legally. If this gets proven, if the evidence is presented strongly, the whole bankruptcy case could be challenged, maybe even reopened or reclassified as fraudulent. It might even get referred for criminal investigation. It's a serious, serious breach of their legal duties.
Okay, so let's piece this together. We've got the official documents showing a company claiming almost no assets, very few creditors, but at the same time, they're launching what looks like the exact same business under a new name.